So briefly, Todd Lyle is a great guy. He's been a real good friend of mine here in town as our business has grown, and his business has gone up and so good that he really doesn't even work in it anymore, right? So, but he has gone through the '08 downturn, and he'll tell you a little bit about that. So a lot of experience in different aspects of real estate investing, but right now he owns a brokerage and is an attorney here in town. So I'd say that to tell you that he's not giving you legal advice, right? I think every attorney says that. Like, he's not giving you legal advice. If you want to hire him, you can. But he has a lot of knowledge and experience in this field. So feel free. We will have lots of time for Q&A. So write down your questions. As he's talking, write them down. Seriously, this is the best opportunity to learn from somebody that's done a lot of lease options and creative real estate, and then the typical flips. He does plenty of those now here in town. So Todd, I'm going to let you run with it, and you guys write down your questions.
So just to get a gauge from the room, so I kind of get an understanding of the level, what do you need to know if you're selling raw acreage?
What do you need to know?
Yes.
And what about how many acres there are?
Lots. You need to know lots. Not getting it. It's my dry dad joke.
Yeah, I got you. Lots.
I wanted to delay that. I wanted to delay and kind of get a seat because, you know, I spent 10 years in the business world thinking lawyers were a bunch of idiots and they messed everything up. And then the market crashed 08, 09, and I got my butt handed to me. I had my hand deep in the cookie jar. And I'll tell you that story briefly, but it's kind of fun, so I wanted to make sure I kind of didn't come across as a dry lawyer. First and foremost, I am not a dirt lawyer. So if anyone ever wants to offend me, call me a real estate attorney. I'm not a real estate attorney, okay? I'm a litigator, but I flipped houses for years and years and years, and so I still do them both. They're both fairly synergistic at times. And then part of it is you build systems and you come up with processes and put a team around you so that you can become efficient and tackle a lot at once. So this is kind of my agenda. I'm gonna tell you a little bit about me, just so kind of qualify areas that I don't know. I'm not gonna tell you a whole lot beyond what I know. I'm gonna talk about lease options, specifically the option, as well as the consideration, two very important parts of it. Then I'm gonna tell you why, and then we'll tell you why on the buying and on the selling side. I've been a part of both of them. Way more on the selling side than on the buying side, but there is a time, there's a place where both can be used as an effective strategy. Talk about the pitfalls of it, and then I'll give an application of it so you can kind of see it. I'll then, of course, open up for questions. And again, as Andrew alluded to, my legal advice will not be given here, but if you do have a question, I'd be happy to tell you what the answer probably should be. But again, not giving you legal advice from the front. Everybody's particular question might have different facts, might have different circumstances that step outside the realm of what your question was told or what I heard. So going through that, I was a math nerd. So I went to college, I went to the Citadel down in Charleston, graduated with a degree in civil and environmental engineering, and I went and worked at an engineering firm for a grand total of 4 months because I absolutely hated it. So it was during the boom of the real estate kind of development boom over in Lexington, which is where I grew up, and I met with several developers as an engineer, and during that 4-month window, I said, I'm tired of sitting on this side of the desk, I want to get on that side of the desk. And so I ended up getting to take a few of them to lunch, learn a little bit, and just walked away and said, I got no wife, no kids, bills are low, I'm gonna figure this out. And so I really, it was baptism by fire. So I got into basically doing a little bit of land development, and then that kind of dwarfed more into, hey, why do I want to take all this time and then build property when I can just buy distressed property that's already built and get a lot quicker turnaround time. So started a real estate company with a business partner. We ended up growing a bricks and mortar business, had about 8 employees, Southeast Investment, Southern Management Trust, a couple different names we ran under. And you see it kind of fizzled out in 2010. We didn't learn how to get off the boat when it was going down. So in 2008, when the subprime market tanked, our business was sitting on about 55 properties, of which most of them were with the exit strategy of the lease option, which was not a good thing when the subprime market dried up. So I switched careers, went to law school, and worked for the government for a little while, went out in private practice, and now I'm with a law firm that I own with a law partner, Lyle. Started that firm in 2015, and then 2016, and I've been playing real estate all along. How many of y'all are conventional? You got your real estate license or you have some kind of certification? All right, I was an arrogant little prick when I was young, and I thought I was really cool if I was the investor and I was better than the agents and the commissions are silly and I'm gonna be the investor. And I stuck that pride up in 2016 and said, I'm gonna start brokerage, and that's one of the best decisions I ever made because got a lot of baptism by fire, got a lot of experience, and I'm very outside the box. So if you want to talk about kind of how our brokerage is set up, we're a little bit different than most. You know, we lend money to sellers to make sure they do 100% of what we recommend they do. You know, our days on market is extremely low, and we just don't do 95%, we do 100% of everything we do, and I'm very picky and selective, which is nice. So that's what, I wear those two hats. I've got a team around me on both of them, and so again, if the question is why in the world do you do two different things, I'm able to do them both because there's a lot of cross-section, and again, great team around me. So let's talk about lease option. How many of you know what a lease option is? All right, so good, many of you don't. So I'll try to dumb it down a little bit and then speed it up kind of for those who do know. To kind of give you an example, it's as old as contract law. You might know the definition of contract is. Mutual ascension, meeting of the minds, material terms, both parties agree. Well, that's what an option is. It's as old as contract law. However, in the 1970s, it got really important. It got kind of popularized because it was a financial instrument as a way of getting around an alienation clause, which maybe you've heard of a due on sale clause, where titles transfer, also the mortgage called accelerated and due. There was a kind of cool way around it, using these options as an instrument to get a foothold in on property, have a title interest in the property, and still kind of have your one foot in, one foot out. So it's creative financing. You might have heard of the Garden-State-Germain Act, 1982. That was a preemption to the due on sale. And then your subprime market crash in 08, you had Dodd-Frank and a couple other statutes that came out and made lending and rules of lending very, very different. And so the option lost a lot of its power from that standpoint, but still as an investment vehicle, it can be really cool. So the construction of a lease option, and this is where I'll get into the fun without trying to sound too dorky as the lawyer. And you'll hear these taught. I was taught off the Lou Brown model. You might know who Lou Brown is, out of Atlanta, big trust guy. Old school, that's where I got started back in the early 2000s. And he's big on trust and he's big, but you know what? Georgia law can't be more different than South Carolina law and all that stuff. So everything he teaches you is kind of good for Georgia. It's not very good for here. A lease option is two separate standalone documents or agreements. And down here at the bottom, each one can stand alone. You can lease a property with an option also in place. You can let the option expire and continue to lease the property. You can continue to keep the option in place and let the lease expire. Two separate agreements, although based on the consideration rules, which I'll talk about in a little bit, there is some overlap. So lease option is a lease with an option to buy. This is what an option is as defined. It's an agreement between a buyer and seller that gives the buyer the unilateral right, meaning they get to select it whenever they want to. No longer, the mutual meeting of the minds has already occurred. If I've got an option to buy a piece of property, it's my choice when I want to exercise that option. I don't have to go get your permission, I've already got it. So when I have an option, I have a specific amount of time with which I can exercise that option and therefore acquire that property at whatever price we previously agreed upon. Everybody tracking that? All right. So what makes up a lease option? There are the elements of an option. You got property, and this is kind of basic contract law, but you got parties, price, you got terms. You have to have all that in a contract. Everybody's heard the story about you can't have a valid contract on a cocktail napkin at a bar. Yes, you can, as long as it meets proper elements. Who's selling and who's buying, what are they buying and selling, how much are they buying or selling it for, and generally when are they going to do it is somewhat important. But of an option, you got property, you got parties, you got price, which I have flexibility on this because you can call a contract when you say you're filling in the gaps. In other words, I'm going to buy it 5 years from now and it's going to be market rate plus 2 points or whatever. So I can say some generality in what the price is, but otherwise you can't have any generalities on what the property is. You got to have a specific legal description. You got to have price, parties, consideration, duration, how long is the option good for, and then miscellaneous if you want any other terms. Hey, if we're going to close, we got to close after grandma's moved out, or some kind of stipulation that both parties, as long as they agree to it, freedom of contract, they can agree to it. So let me give you a quick example. These are the silly names. If you go to any other seminar, you can use Bob's and Sue's and sellers and buyers. Sue owns a house at 105 Park Street. She wants to sell it. Bob wants to buy it. Bob doesn't want to buy it with full outright purchase price now. Bob wants to get an option. Lots of reasons why, and we'll talk about it in a minute, why he would or not want to do that. So he agrees to pay some kind of a consideration. Important that I say non-refundable, because this is all just an example, but $2,500 is the consideration to get that option. There has to be some consideration given for it to be binding. And then Bob's got to exercise this option within 24 months. So if we go back to the elements, we got the property, 105 Park Street, we got the parties, seller and buyer, we got the price, the $100,000 that they agreed to, we got the consideration, $2,500. I put plus the lease because in some instances the lease can be considered consideration, but as legal advice, I would not recommend do that. If you give the opportunity to do some additional consideration, that furthers the argument that consideration is being given. So let me talk briefly about consideration. Consideration, legally, definition is a benefit which must be bargained for between the parties. It's the essential element. In other words, if it's not a benefit and it's not a bargain, then it falls into what we call a gift. And that's kind of a cheesy analogy to use, but that's actually what the legal definition is when you give something to someone with no expectation of something in return, or there's a little bit of a gray area as to what is being accepted or expected in return. So you definitely want to have consideration. Without consideration, you don't have a contract, therefore you don't have anything enforced. All right, this will get into a little more fun stuff. So why? Can anybody guess why you would want to use a lease option? On the buying side, if you're buying something, why would you want to do a lease option? Anybody? Give me an example.
Maybe I couldn't qualify otherwise.
Finance, exactly. Cash flow, can't afford it. Credit, that's another reason. Exactly. So let's say you can get financing, but you want to buy multiple properties, but you can't afford all of them. Getting an option on several of them will allow you to then acquire and move on to the next one and potentially roll down the line. And so you can maximize your leverage. Timing, I'm going to tell you a fun story. How many of y'all know a story about Walt Disney? Okay, Walt Disney started out in Disneyland in California, and he built what is now Disneyland. He did not get enough acreage around him. He wanted to have this secluded, fun park that didn't have anything else near it, and he wanted to be insular. And he realized outside of Anaheim, California, that he couldn't get that kind of buffer. And so in the 60s, I believe, he said, I'm going to go do this right this time. So he goes and scours the country looking for a place where he can get enough acres. Anybody know how many acres are in Disney World in Florida? About 30,000 acres, 47 square miles. Do y'all know how much percentage of that is actually theme park and not just buffer? It's about 11%. 11% of Disney World is actually developed. The rest of it is just acreage. Do you want to know how he did it? He set up numerous shell corporations and ran around and got options, because who in the world could buy all that land at once, or who could buy some of it and not let the word get out such that the last few pieces and parcels cost an absolute fortune, which in this case it actually did. Fun fact, Walt Disney paid $80 for the first acre that he bought in Disney World, and he paid $80,000 an acre for the last acre he bought just a few years later, because people got word and figured it out, supply and demand. So, but using options, Walt Disney was able to tie up and put a lockdown on every piece of property that is now part of Disney World. Another reason is speculation. I had a client several years ago in a fairly urban area nearby here, have a commercial lease. It was actually a good many years ago. Several years ago, though, he thanked the heck out of me for this, because he put a lot of improvements into an area that, into a property that was in an area that wasn't real popular at the time. And he said, what do you think I should do? I said, you should go ahead and get an option. And at the time, the building was probably worth about 320 grand. He put about $60,000 into it, and I said, if we give you a 10-year lease, I said, go ahead and get a 10-year option that you can buy for $500,000. He's like, I'll ask him. The guy said, heck yeah. And then, just about 2 years ago, it appraised for about $1.1 million, and he said, heck yeah, and exercised his option. So if you speculate, you can win on an option as well. So on the selling side, this is where I made my money. This is where Andrew teased a little bit about this little model that I use that not really can use entirely anymore, but I will say that the subprime market is trying to make a comeback. When selling, why would you do it? You get commitment. I will tell you that there is a massive difference. If you're a rental, if you hold rentals, if you just advertise them as rent, to own, which is another way to do lease option. I probably should have prefaced that. There's a lot of different names we can use. Lease purchase, lease option, rent to own, not necessarily owner finance. We can talk about that a little bit later, that's different. But there is no actual title interest other than the option. It's not an actual equitable interest, although our courts have deemed it to be an equitable interest, and I'll talk about that later. But when you sell on lease option, just a regular house that would otherwise be a rental, you get the commitment from that tenant. If they're really invested and they're the right tenant, they're going to treat it like their own. They're going to say, hey, do you mind if I build that deck on the back? Heck yeah, go ahead. That'd be great. Hey, do you mind if I, upgrade the kitchen? Sure, why not? Go ahead. These things that if it was just a regular rental agreement, they'd say, I'm not kidding. Or the lease would even say, I got to get permission to do that. Or no, you can't. No alterations. You've seen that in a lease agreement. No alterations. Can't alter it. Well, on a lease option agreement, heck yeah, make it yours. Obviously, you want to screen the tenants correctly. Tax advantages. Does anybody know the difference between a dealer and a wholesaler? Or a dealer and a W-2 income if you sell a property less than a year? If you buy and sell, it's basically the IRS deems that to be a dealer of property, and therefore it's like straight up W-2 income. So if you do a lease option, you can potentially hold it for more than a year and a day, and all of a sudden jump yourself into the capital gains bracket, which depending on the administration or the flavor of the political sphere, that's a lot better deal right now. And then I'm going to call it the super realm. And the reason why I do that is I'm going to give you some stats here. Well, let me tell you what. Let me do the pitfalls. I'll come back to the stats. Remember that super realm, because then I'll give you some of the numbers on what happened in Southeast Investments. So here's the pitfall. When buying, you have got to record your interest. This is the biggest mistake that any of you could make if you get an option, okay? If you have a vested interest in a piece of property and you do not record that interest with the Register of Deeds office with which that county is residing, that particular owner who's not conveyed title to you yet could go get in a divorce, could go get drunk and driving in the rear end of a house or a car with minor children in it, and all of a sudden become a tort creditor. He could go have a gambling problem, he could have a drug problem, he could have all sorts of problems and run up and get all sorts of crazy debt and judgments against him. And if he's still got that property in that courthouse, if you don't have your interest filed, then guess what? Those guys get in front of you when they file their interest. So highly, highly, highly recommend if you use it on the buy side, you have got to, this is not negotiable. You have got to record your interest. I never knew this when I flipped houses before I became a lawyer. I didn't understand. There's a few little tricks I'll tell you one day if you want to pull me aside. Actually, I'll give you one of them as an example. I did all our own property management for all our rentals, and I relied upon the sheriff's department to do all my process serving whenever I had to file an eviction. That was the dumbest thing I could have ever done. When I became a lawyer, I figured out how process servers work, and not using the sheriff's department. They're really reliable because it's a competitive business. They don't cost hardly anything more, and they'll guarantee you results when you get it served immediately. So if you're managing property, use a process server. You don't have to be a lawyer to use one. Use a process server. Don't pay $80 to the magistrate and let 60 go to the sons of complaint and 10 or 20 go to that Richmond County Sheriff's or Lexington County. They don't have time to try to serve. They're going to do 3 null bonus and say we're done. Anyway, my 80. So recording that interest, you got to record that interest. If you're going to get an option, if you're going to do anything, record that interest on the buy side, not on the sell side. And then on the buying side, the problem is you do have to compel them to enforce it. What I mean by that is just because you have the right to do something doesn't mean it automatically happens. This is just like anything in life. It means that you have the right to do it, and you're going to have to take the steps to enforce or compel that right to come into play, unless they're nice or they play nice by the rules, or they follow the terms of the agreement. But still, it's a hindrance. In other words, it's not an automatic. If you have an option and you say, I'm ready to exercise that option, you're right, you have the right to do it, but just the negative side is if the seller says, I ain't showing up, I'm not signing the title, that's great, but you're going to take several months and several $1,000s in court orders to get them to be compelled to finally convey title. When selling, pitfalls are the equitable interest, which is by far the #1 hot button that I could probably answer questions all night for. And then it does cloud the title, because technically speaking, you're giving an equitable interest. And so I think I've got a slide for the whole magistrate court debacle, and I'll go through that in great more detail. All right, so here's my story. We started Southeast Investment in 2003, started buying houses. I worked my butt off and had very, very picky standards, and ended up realizing I passed on a whole bunch of deals that later in life I would have done. But around '04, late '04, '05, we started picking up and buying 3, 4, 5 a month, and we had a machine, and it was, we were doing TV commercials and billboards and had lots of stuff. Out of about 100 properties that I sold as a lease option exit strategy, about 90% of them cashed us out. Not a single one of them did it on their own accord. Not a single person who I put in a house who said, I got marginal credit, I'll get it up. Not a single one of them, out of over 100, not one went and got their credit up without me doing some help to get them there. So that was a very interesting lesson learned, because what that basically tells you is if somebody's got marginal credit and you're gonna put them in on a lease option, your exit strategy needs to be, hey, the numbers work right now, not I hope they cash me out. If the numbers hope they cash you out, then you'll lose $1 million in equity in 2008 and 9 like our business did. It was awful because people can't get their credit up on their own. They just don't. Of the 90% that I got to cash me out, it was, hey, Mr. Mortgage Broker, can you meet with them? Yeah, what do they need? Okay, I got to coach them up. They got to go finance a lamp from rooms to go. They got to go get a credit card that they get their parent co-sign. They got to quit buying a stupid car that costs way more than they can afford. You had to counsel them up to it. But you could. In '08, before it all collapsed, you really could. And you can still do it today. It's just a lot harder because the rules are a little stricter, although the rules have loosened up a lot. In fact, just a few days ago, the rules got loosened up even more for the banks. So you heard it first, it's coming back. But that's why I call it a super run. So let me give you the numbers on this, all right? So let me tell you why the lease option worked, all right? So this is coming from Todd Lyle, who's also makes money off of real estate commissions. So you're not gonna get a buttery side of this. You're gonna get the real deal numbers here, okay? Because I do invest and I still do flip. This is the standard deal, okay? You stick it on MLS, you've looked at all the comps, this is kind of where you gotta land on your value. You gotta pay a commission. Okay, yeah, maybe you don't have to pay all that commission, but you're probably gonna pay some of that, if not most of that. You're gonna have to pay closing costs, because today, nobody's got cash. So when they make an offer, they gotta, we had 12 transactions in Todd Realty Partners in July, and 2 of those did not need closing costs. The rest of them, they all wanted $2,500, $3,500, $40,000. I had somebody ask for $9,000 in closing costs on it. Bought a $200,000 house not that long ago, and asked them what in the world that was for, and they didn't have a really good reason. There's a lot of people who don't really have a good pulse on everything. And then they're going to inspect it, and then they're going to haggle you and beat you up and say, I want the fix, I want this, and I want you to throw me in the fridge, hey, washer and dryer need to stay. And at the end of the day, you're netting less. Well, this is how it works in the lease option. And I'm not making this up. This is legit numbers. On the lease option, you're selling payment, okay? You're selling, hey, you're paying me $1,200 a month. You can get a mortgage, and now your price goes down to $1,080 a month. And so all of a sudden, you're stretching comps because, in theory, you can find one. You can always find a comp if you're just stretching a little bit. Maybe a brand new subdivision, Mungo, D.R. Horton, where you got 80 sales that are all real close. Yeah, you can't stretch on that. But if you're dealing with Columbia, if you're dealing with Keenan Terrace, my focus area back in the day was Elmwood Park, Earlwood Park, Keenan Terrace, and then we kind of got into Eau Claire, that whole 29201, 29203 section. But this is what real numbers. You put on MLS, you're gonna get 100 for it. You put it on sell on payment, whatever that top comp will give you, so you get 110. You pay commission, nope. You pay closing costs, nope. You haggling over repairs, nope. Nothing. And you're netting literally $22,000 more on a $100,000 deal when you sell conventionally versus lease option. This was make the bank money through the 2000s. This was why we were killing it, because we were putting people in and selling house on payment. So this, as the subprime market doesn't necessarily return, but as you hear commercials on the radio, it says, hey, 1 month out of bankruptcy, we can get you a mortgage, and you start hearing those, or hey, 1 month's bank statement, you're self-employed, great. We're starting to get into that, what was called Alt-A and Alt-B credit type loans, and those are the ones that are a little more loose, fly by the seat of the pants. Never would encourage you to do anything misrepresenting, but if the loan product's there, take advantage of it. So, this is where I get into my equitable interest. So, does anybody understand, or does anybody know what I mean when I say equitable interest on a lease option? Okay, so if you've got a tenant on a lease option deal, and all they do is pay you rent. If you have proper authority to evict them, you can do that under a breach of contract theory. You can go down to the local magistrate, and he's got jurisdiction. By our state constitution, his jurisdiction goes up to $7,500, and it does not go to any real property interest. The Court of Common Pleas, which is big boy court, which is above $7,500 and deals with other certain areas of jurisdiction, and the master and equity are what handle real property interest. So what that means is, if you get a tenant who also has an option agreement, who's not paying their rent, if you go down to the magistrate's office and file an eviction, if nobody says anything, then you're great, move on. If the tenant comes forward and says, I thought I had an ownership interest, I thought I gave you $2,500 down, I thought I was going to build that deck, I thought this house was mine. That judge has no more jurisdiction. He, by law, by the Constitution of South Carolina, cannot hear your case. He cannot order an eviction. It immediately gets removed up to Common Pleas Court, which is stick your tires in the mud, slow way, 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 way down, and all of a sudden what could have been done in 30 to 60 days probably takes 6 to 18 months, depending on if they get a lawyer, depending on who the judge is assigned the case. So that's a real concern, right? If you got hosed on that every single time, you would not find this to be a viable option. So it's a numbers game. Well, I gave you the kind of core sampling of 100 ones that we did. I think I maybe had to evict about 2 or 3. I had another 2 or 3 that we went ahead and got ready to file, but we basically, when it got down to it, they vacated and left.
How long did that take?
Which one? Well, okay, I can give you one horror story. If y'all were here for the Saturday talk I did, I'll give you one true horror story of a con artist. I learned another valuable lesson before I became a lawyer than that. But I've had one con artist wear me out for about 8 months. I learned some really valuable lessons on that. I had somebody literally stay in the house for 8 months. And that's, our magistrate judges are not usually lawyers. They're just appointed delegates. Whereas our circuit court judges are. They're lawyers who practice for a long time and then get put on the bench. But the one that hit me up 8 months, it was a lady who said, my kids aren't being fed and I lost my job. And the judge looked at me and said, ma'am, you got 90 more days. And then 90 days later, we showed back up and she still didn't have food for her children. And the judge gave her another 45 days. And I was like, okay, I'm paying taxes, insurance, it was bad. But that's magic. It can happen. So what do you do if you give a lease option, vested interest to the tenant, and you want to avoid this problem? Well, number one, you do enough of them where if you do get the one rotten egg, the benefits far, far outweigh this. An analogy I'll give you is when I used to live downtown Columbia, I did a lot of parking up and down Main Street, and I got tired of feeding the meters. And so I got nerdy with my math and said, I'm gonna keep a spreadsheet of every time I park and the amount of time I don't pay for, and then I'm gonna offset with the tickets I have and just see which one came out better. And it actually came out about 40% better, not ever paying the parking meters and just paying the tickets. Now, the caveat to that is I only ever parked 20, 30, 45 minutes at most. I never parked for a 2-hour block of time. But I realized it's a lot cheaper just to pay the tickets when they come. And so, I'm not making this up, that's really me. I never fed meter. And it sounds like I'm not the only one who does that. But the analogy would be the same on this lease option thing. If you get 1 or 2 that beat you up and maybe drag you out through court, if you got a bunch of other ones where you're collected, make no mistake, nobody got a free option on any of my houses. It was $4,000, $5,000, $6,000, $7,000 down. So they're putting down, let's just say easy math, $5,000 on a $100,000 house. Well, there goes, that pads up the stack in case somebody does pull that card, because it's paying for my holding costs and paying my attorney's fees. So you win a bunch and then, okay, this one I don't win. But if it's your first deal ever and you get hosed on that, it's gonna hurt. So you wanna have enough instances to offset this potential thing. But okay, so let me go to what else can you do? You can try to enforce, and what I mean by that is you just go file the eviction. Okay, our court systems say, we don't really care what the rules are. If you don't object to it, then it comes in. Everybody heard you can't, it's court TV, you hear a hearsay objection and that can't come in. Well, if they don't say objection, it just keeps coming on in. One side's gotta object, the other side can't just say, well, that's the rule, I can't do it. They just keep going on and on and on. If the other side doesn't enforce, then you just keep on going. So you try to enforce the lease. Just file an eviction. You have no duty to walk into the magistrate court and say, yeah, it was a lease option, they got an equitable interest, so I know I can't really file this here, but I'm gonna do it anyway. So you've got a lease option, you've got a separate lease agreement. On its face, you can go file the eviction. If they show up and say, hey judge, I thought I owned it, well, then you're probably in trouble and you should have avoided getting that step, which is where you get into renegotiating. If they're going to show up to court and they're going to want to tell their side of the story, that's when you pull them in the back and say, what are you doing here? You know, and that's where, I may have told this story months ago when I last spoke. I'm part of a little listserv, and it's always fun because, again, I spent about 10 years before I went to law school doing real estate, and I'm on a little email chain with a bunch of other small solo practitioner lawyers who ask questions and they'll get responses, and occasionally I'll get one or two of the whole, they're not paying rent, what do we do? And I'll never forget, I answered this one question. There's several old, long, in the tooth lawyers who wrote back and were like, Todd, that's the most thoughtful and the most non-lawyerly answer I've ever heard. It makes so much sense. But I walked them through, you can enforce all these rights. The court will give you a date, 60 days from now to show up. Or you can look and go, here's $1,500, stand on your doorstep, come give me the key, and we'll do a little swap here and do what the banks do called cash for keys. It's far more efficient. So if you got somebody who's going to try to say, hey, Equitable, but most of the time there's a 1% chance they even know what that rule is. If they got a lawyer, they do. But if they don't have a lawyer, they're probably not going to be able to say, hey, I got equitable interest, you got to foreclose. Well, by the way, I didn't say that. If you do have equitable interest, you got to foreclose. So you just had a lease option that you just were treating like a little rental house. You now have to treat that just like your Bank of America, and you got to foreclose on that because they have equitable interest. So you can renegotiate, cash for keys, change the deal. Look, you gave me $5,000. I know you can tell them this, but you can drag me out for 4 or 5 months. Or I could turn the property around and get somebody back in there. So what's it going to take? $2,500? You want me to pay your moving truck? You want me to pay your down payment or your deposit at your next place? I'll pay it. Gladly pay it. It's much more efficient, much easier way to get through that. And then the last one is lawyer up. If you do get stuck in magistrate court and the judge goes, oh yeah, equitable interest, you got to go up to the master in equity. If that happens, don't do that alone. In fact, our lawyers' rules are very self-serving. In fact, this is probably good to know. But technically speaking, if you own property in a corporation and you go represent that corporation and you're the sole member or sole manager of that corporation, technically speaking, there's a Supreme Court order that says you showing up on behalf of that corporation, even though it's just your LLC and it's your house, you're now conducting unauthorized practice of law because the corporation is a separate entity and you're not a licensed attorney. So again, it's a very self-serving thing to say, but I do mean it. Go ahead and try it in master court, but if they do push it up to the master in equity, they're not going to let you talk to the court. They just won't let you do it. If you own the house in your name, yes. But if you've been smart and put it in a trust or incorporated, technically speaking, that judge should say, I can't hear from you, sir or ma'am. You're not an attorney. And Citizens United, famous Supreme Court case in the United States, was reaffirmed several years ago that corporations are people too. So it's not an alter ego, it's an actual separate entity. And so if you want to show up as the sole beneficiary of that corporation and try to represent it in court, technically that judge should say, I can't hear from you. You're not a licensed attorney. So, and I put an asterisk next to your lawyer up. Another reason why you get that option fee. Get $5,000 from them, get $7,000 from them, because you may need it. It may not be profit. That took me to questions, although I want to say I was going to back up to the super rental. I think I did talk about that. Super rental, so the super rental, that analogy was just under my 0% of them cashed me out on their own accord. That's all they are. It's a super rental. They treat it like their own. You don't have any maintenance calls. They take care of it, at least they should. And they paid you a whole bunch of money down so that whenever they decide they're going to move on to life and leave you behind, they forfeit the option money. I don't think I ever. No part of that option money is a deposit, okay? When you get the paperwork done right, they've got a security deposit, they've got a first month's rent payment, and then they've got a option fee, which is consideration for the option. It's not, those are 3 separate pots and they never play together. They're all separate monies. And in fact, if you commingle them, you run the risk of losing your argument that it was an option. So, which I guess could be in your favor if you're on the selling side and you don't want to go up to big boy court. But if you're on the buying side, you definitely don't want to have those things commingled. So, questions? A little too much? Go ahead.
What happened to the 10% of people that you did not keep your full term? Did you all just get your money back from all those, or I know you said you got a lot of them.
I still hold some properties, and a few of them are carryovers from those days. They turned out well now, but at the time in '09, I would have liked for somebody, I'd like a homeless man to go burn some of my stuff down at one time. And I mean that, honestly. I would have never done it, but I would have sure liked somebody to.
Explain how you made $110,000 plus the $22,000 on that lease option.
Okay, so for the conventional salespeople out there, you put. I listed a house last week in a neighborhood that's 3-2 vinyl siding. There's about 180 houses just like it, and there's one or two outliers. Somebody's got a brand new workshop in the back, and they got stainless appliances, and an appraiser got kind of roped into doing a nice little 5% adjustment up, and then they found another 5% adjustment. In other words, what you're going to do is you're going to be able to take yourself to the best comp. So this one particular neighborhood, the comps were between $103 and $117 a foot, and in the condition of the house, because it's not perfect, it's probably $105 to $107 a foot house. But you go lease option, you're not negotiating price with them. Okay, they don't. That's not what their thought is. Their thought is, I'm paying you $1,200 a month. If I buy this thing, I'm going to be paying $1,080 or $1,060 or whatever, depending on the interest rate, PITI. Because until interest rates climb up, it is always, I guess that's a good question. You should never structure a lease option where the rent payment is not more than what the eventual mortgage payment would be. So don't put them in. I may have done that once. If they're paying $900 rent, and then you go, hey, let's get your credit up and buy it, it'll be $1,100 on your mortgage. Well, I don't want to do that. They won't pay more. You entice them into paying less because that's what the mortgage conventional rates would be. Does that make sense? All right, so I got you the price up, right? 10 grand, so from 100,000, we're about 110. And again, these are rough figures. For a particular neighborhood that you might come to me one day and say, hey, I tried it, it came out to 108.7. Okay, all right, I don't know what the best comp was, but it always sells more if you're not negotiating price.
So why don't you pay the commission and closing costs on it?
Because you put your tenant in. You got a rent to own sign in the yard. And Steve calls you and says, my credit sucks. I want to buy that house, but my credit sucks. And you say, well, that's great. We've got a rent to own program. Well, how's that work? Well, I need about $6,000 down, and your rent payment's going to be $1,200 a month. And hopefully we'll get your credit up one day, and I'll give you that option. What money you put down, we'll credit that towards your down payment, and you'll get credit for that. And 100% of the time, they won't do that unless you help them do that. So, so you've got the no commission because you put them in there yourself, right? You're not haggling with them because they don't, having lived there 2 years, go, I decided I want some blinds put in before we go to closing. I want some curtains and blinds. They don't ask for that kind of stuff when they've been living there 2 years.
So they're paying the closing costs.
Yeah, absolutely. It's never even, I'm sure it could happen, but I've never had one. I've never had a lease option tenant get their credit up because I helped them get it up and then go, I was just thinking, we ought to renegotiate this. Never had one. Never had it. They're already in the house. They're already committed. It's different than when they're in the car with their buyer realtor and they go around and look at 20 houses and their realtor's in their ear trying to make them feel like they got them a little last parting shot. 'Cause that's all it is at the end. When you get close in the range of what's fair and what's not, it's a playing chicken. It's two agents saying who's going to get the last little dig. Does that answer?
Yeah.
All right. In the back.
You use the note services company and do an RMLO on the tenant buyer.
So, ask that one more time.
You service the note for the tenant buyer.
I'm sorry. One more time. ADD.
Good. You service the note for the tenant buyer like the servicing company.
No.
And then you do RMLO.
No, because you just definitely locked yourself into a sweat equity or an equitable position.
Yeah.
If you're servicing a note, now you've got some federal rules you need to be looking at.
One of the seller financing stuff like that.
Yeah, well, okay, if you want to get into seller financing, I don't do it, but I have a company that I did that a couple times. The guy that did that for me back in the day ended up going to federal prison because it's a whole bunch of you got to do it right, and it just wasn't worth it to me. So if you want to play like Bank of America, you got to have the checks and balances and the PCAOB accountants. You got to have. They can come audit you, and there's just so many. So yes, you can do it.
Yeah.
Just like the lease option thing, you can try to file the eviction, and you may not get caught, but I wouldn't want to violate federal rule. And so I used a guy, and I used another guy after that guy got closed down, and it wasn't worth it.
Yeah.
To me, I like holding the title too, which I don't want to go too far into that road, but you've got straight rental, then you got rent to own, which is where you're kind of dipping your toe in the water, and then you've got agreement for deed, which is, South Carolina would call that a land contract, which is where you actually push the deed in the middle of the pile and say, if you do all the terms that we agreed to, then the deed has to go by trustee over, which is kind of a halfway in the water, and then jumping all the way in the water is I'm the bank and I'm going to be full owner financing. I'm not scared of owner financing. I am scared of it if you're going to report to the credit bureau. If that may be, I may miss your question. If I just straight financing, straight servicing, you can do that. I still don't like it, but you can do that. And if you do that, I recommend strongly that you just do simple interest, something very simple. Because if you start doing 30-year AMs, somebody says, well, you didn't send me a 1099, you know, or you didn't send me a mortgage interest statement. That's a per se violation, which means if you didn't do it, you're wrong. You don't have to harm somebody. If you didn't do it, you're wrong. So I do a lot of plaintiff's work as a lawyer, and one of the ones I love is I love beating up on these predatory lenders, and I love beating up on banks who lend money and don't satisfy mortgages, because we have a public policy statute in South Carolina, many states have it, that says if you lend money and you record a mortgage against the house and then they pay it off, as long as they've paid you off as you've demanded it be paid off, to include a recording fee of $5, then you got 90 days to satisfy that mortgage. Otherwise, there is a $25,000 on its face violation, or half the amount of the mortgage, whichever is less. Per se violation. Doesn't matter if you had a bad day, doesn't matter if you got sick or you put the wrong address. You got 90 days. At the 91st day, if that mortgage is not satisfied after having tendered payment, and it was a public policy statute. We didn't want First Citizens to lend you money as fast as we can, and then when you pay it off, you still sit around and cloud the title because you're lazy. And so it's great. I love the state. I love suing people for that. That makes me really happy. I sued a bank out of Nashville a couple months ago that had put an improper lien on a mobile home, and it just made me really happy that day. I enjoyed it a lot because I don't like lenders lending money and not clearing titles after you get paid off. Sorry, get passionate about that one.
You said that becoming a broker was the best decision you ever made, so I want to understand why you said that. And in South Carolina, you have to have a realtor's license in order to become a broker.
Yes, you did.
Didn't hear the question.
So the question was, why was becoming the broker the greatest decision I ever made? I'll walk it back and say it was a really good decision. I'm not going to say it's the best decision I ever made, but it was a really, really good decision. I'm very glad I did it, and I'll tell you why. And then the follow-on question was, in South Carolina, what do you need to do to get your broker's license? And I don't want to play trivia on the spot, but if you have a degree from a law school or from an undergrad that's a specific real estate type degree, you can just go sit for the exam, and you don't have to do all the steps prior to. But if you don't have that and you got to do all the steps prior to, you got to take the licensee class, which is the sales agent class. Then you got to work underneath the broker for 3 years. Then you got to take a broker A class, and then you got to take a broker B class in order to be able to sit for the exam. So there's a lot that you got to do. And the reason why is a broker in charge is not about selling. A broker in charge is not about how to make good flyers or how to get the right for sale signs. It's all about, it's first year property law classes. Like if you go to law school right here at USC, your first year, there'll be a property class you take that talks about leasehold estates, freehold estates, and that's basically what a broker in charge is making sure you follow the agency laws. So the reason why it was a great decision is I think it's very synergistic with what I do. On a monthly basis, my law practice gives my real estate company business, and my real estate company gives my law practice business. So they're very synergistic. It also gives me an edge when I deal or compete with other agents. Like if you list your house, here's a sales pitch, it wasn't meant to be, but if you list a house with me, you're gonna get a lawyer representing you. I'm not going to say I'm an agent. I'm gonna negotiate the contract as a lawyer, knowing the law. I'm going to make sure the property disclosure statement's filled out. I'm gonna put a poison pill in your contract. Ask Andrew about this. If you'd ever resided in the house, the last thing I'm gonna let you do is not disclaim and disclose that, such that the buyer knows that he's put on notice that we can have this silly statute that says, I gotta do all these disclosures. I can stick a poison pill in the contract that completely overrides that. It's very well known, stood up in law. I will prepare your seller closing documents for you. I will meet with you and execute your closing documents for you. Andrew, how many times have you been in my office to do your closings? Yeah, I do his closing for him. And so, because I know the lawyer doing the closing for the buyer, and so I'll prepare the deed, I'll meet with my client. And so they're just really synergistic. When I meet with someone, a prospective seller, and I get to give them that pitch compared to what they just heard from somebody else, they generally like my pitch. So I really like that. On the litigation side, I was in a big date certain trial back in May over a property disclosure statement, $800,000 house in Forest Acres, that a couple of people worth a couple $1 million sold to another couple of people worth a couple $1 million, and then they got flooding issues and they big lawsuit. But I actually was the litigator. I wasn't a real estate agent. I was a lawyer, but I actually defended that case. I wasn't the plaintiff. I was the defense. And just having there were 4 other lawyers in that deal because this plaintiff sued their own real estate agent, personally, their own real estate agent's company. They sued my client, who's the seller. They sued my client's agent personally and my client's agency. So there's actually 5 lawyers in the deal. And out of those 5 lawyers, probably 20 years experience at least on all of them, except me. And they didn't know flip about what they were doing with respect to the issue of the real estate. You know, I'm climbing on, like during deposition, I'm climbing on MLS and pulling up comps and asking the guy about, have you seen this one, this one sold for? Like, what are you talking about? I mean, just running circles around. So that's a very niche area where those two cross-sect. So it makes me not as good a lawyer in other areas of the law, but if I stay in that lane, I really like it. They're very synergistic. It's not like being really good at farming and then being really good at, computers. I mean, it's like 2 things that have a lot of cross-section.
So you're saying it was great because you have a laundry, not because of your business?
No, they both work off of each other. In other words, my real estate company has made money that it would not have otherwise made based on me being a lawyer.
So if you weren't a lawyer, would you still want the broker's license?
Yes, yes. And that goes back to 2. When I was, who was it that was Lou Brown? I know you said Lou Brown. Anybody else know Lou Brown? Lou Brown was kind of like, okay, so everybody knows who Carlton Sheets is, right? Late night promotion, everybody's Carlton. Lou Brown was right after Carlton Sheets, okay? I'm showing my age a little bit. But Lou Brown was out of Atlanta. He's still out of Atlanta. Good guy, I think he's retired. But his whole business model, I modeled and copied it for the first 4 or 5 years. And it was a smoke and mirror shell game. You were taught as the owner of that trust that owns that real estate, when that tenant calls you, you were trained to say, I don't know, ma'am, I just work here. I got to talk to management. I have no idea. It was this shell game. You never owned property. You were the lowly guy showed up in court. I'm just working here. I mean, that was how you played. And so it was a very I don't know anything. I'm not worth anything. It's the ultimate. He called it asset protection incorporated or something. He had this whole trust thing set up. And part of that was, I hate real estate agents because you're out and about and in your face and, hey, it's me, look at me. Whereas the trust thing was, hey, don't look at me, you don't even know who I am. I'm just the pool boy. And so we were taught that growing up. And I, for the first 4 or 5 years, played that game and said, those agents are too busy about putting a spotlight on them. They're worried about a commission. The real money's in the flip. And some of those HUD statements showed the real money was in the flip. But you know what? The HUD statement shows a commission too, and when the HUD doesn't show a whole lot of money to the seller, it still shows a commission. And so it's a diversity thing. It gives me multiple modes of income. Don't get me wrong, I've done closings for Andrew where little real estate commission ain't that great compared to what he's net because he's done a good job, done a good flip. But I like them both, and I also like it because I list my own flips, so I save on that. I get to hire myself to sell my own property. So, any other questions? I'm rambling at this point. I can go on and on. I can go on and on and on. Go ahead.
Given the potential return of subprime mortgages, what would you do differently now that you did not do?
Oh man. I would do more what I'm doing right now, which is not borrowing a lot of money from the bank. I'm very picky, and if a really good deal comes along, I used to want it, and if that meant I had to go borrow more money to do it, I would do it. Now, my wife's got me on a 1 at a time rule, and if something really good comes in my lap while I've already got my money out on one, then I'll bring it to the room, make y'all happy with it. But that's kind of been my wife's been big on the 1 at a time rule, and I've not broken that rule, although I've had a couple good years in a row where I could probably have to borrow money and still do more than 1 at a time, but I'm not dooming and glooming it because the market always corrects itself and always shifts. But the guy that I was in 2008 was a dude super leveraged with a bunch of assets and a whole bunch of debt. And another thing that happened was 2008 was when House Bill 388 was passed, which if y'all aren't familiar with that was where the property tax, ad valorem taxes were significantly changed to make the 6% millage. Has anybody ever noticed why 4% and 6% are not, 6% is not 50% more than 4%? Y'all tracking me mathematically? It's not. Like in Lexington County or Richland County, it's about 400 to 600% times. So if you got a rental property that you used to live in and you paid $1,000 a month or $1,000 a year in property taxes, it would be about $4,000 to $5,000 to $6,000 a year in property taxes. And so that happened in 2008. So I'll never forget, I was looking at a spreadsheet. I had to call my banker and tell him we weren't going to be able to pay our taxes. At the end of 2008, there was about 300 grand owed to Richland County for some properties and another about 300 grand owed to Lexington County. And I was just looking at this going, holy cow, what happened? And you know, it doesn't matter how much equity you got. When you got to stroke out 600 grand in 2 counties, that's tough. So we were sitting on a bunch of property and a bunch of lease option tenants who were cashing us out and feeding that cash flow machine. And then when that subprime market stopped, I had a bunch of tenants who couldn't cash me out. And so it was, but I'm here today, it's good. Go ahead.
Another question. If you do like for 1 year lease option, and you get that money up front, the deposit, for some reason in a year they want to renew because they can't buy it.
It's a whole new renegotiation. It's a whole new renegotiation. Okay. What I would do in the scenario where nobody ever really cashed me out unless I pushed them, I would give them credit for it, because if I could really push them forward and get them financing, they would want that credit for that down payment. But the percentage of those who didn't cash me out, they moved on and they didn't ask for it. Nobody, I say nobody, maybe 1 or 2 ever called me up and said, hey, we'd like a refund, which is when we would send them the option and the big bold. Again, there's no value in kind of hiding the deal. Like the option guy needs to know, big bold letters, underlined, this is non-refundable. Like I am taking this property off the market. I am committing to sell it to you whenever you want, whenever you can, at this price over the next 24 months. So this is my consideration. This is non-refundable. So, you know, if you wake up tomorrow and have buyer's remorse, okay, I'll do the nice thing and probably say we're good. But if 6 months from now you decide you got a job transfer, I mean, that's just whether I got kindness in my heart, and if I'm in a good cash flow position and you're in a tough spot, then hey, I can assess that. But legally and ethically, I don't have to give any. That's the consideration that we talked about earlier, which I probably glazed over some of y'all with the legalese. Go ahead.
Yeah.
Go ahead.
Can you do the same thing with, let's say it's an owner that's trying to sell it, can't sell it for whatever reason, and you step in and present a lease option, and then you go get a buyer, put the 2 together?
That is called a sandwich lease option. And yes, you can. It's a lot more complicated. I've only ever done a few of them. One of my original business partners, he ended up staying down in Charleston, did several of those. What he's talking about is a house that's on the market, can't get it sold. You come in and say, hey, I'd like to market it and find somebody to be your lease option buyer, but you go ahead and lock in the price. Hey, if you're willing to, it's no different than flipping a contract. You get the old man to say, I'll take 80 for it. You don't really buy it for 80. You go play middleman and go run around trying to find somebody to pay you 100 for it. It's a sandwich, you know, but the lease option works the same way. I've seen a few of them done. It's complicated. Don't put a lot of your money out on that, because there's a lot of things that you can't control. So it may turn out well, but there's a whole bunch of variables that could change it to where it doesn't turn out well and you didn't have control over it. So you don't want to.
You don't have the title.
Right. You don't have title. You got a chance to get the title, but you don't have to. And you're also relying on somebody to get financing and pay you out.
So selling on terms, as far as protection, you would definitely say go with the lease option opposed to
Absolutely.
financing. There are some risks depending on what state you're operating. There's just a lot of liability.
Absolutely. So I went through rent to own or lease option or lease purchase. There's a lot of different names for it. Rent to own is the best thing if you're selling. It's the worst thing if you're buying, so to speak, generally. Then the next step would be, you know, the agreement for deed, and then you go into the actual true owner financing.
Okay. So if you're most dangerous is transferring the deed over to your end buyer.
But if I'm buying, I want him to transfer it to me.
Correct. And if
Right.
you're holding it, you want to hold it
Correct.
until the installment's paid
And
off.
part of that is a lot of reasons, but part of the reasons are, you know, there are tax advantages when you hold the title versus when you don't. So that's one of them. Another one is, you know, you've got leverage, and then The simple rule that you have to compel your rights. You don't have to compel your rights when you're holding the title. If you're the buyer, you don't have to compel your rights if you've already gotten them to give you the title. Does that make sense?
Right.
There's still, so property law is nothing more than a bundle of rights and rights with which you can enforce, but when it comes to like conveyances of property, you have the right to have a deed conveyed to you. You still got to go through a bunch of steps and hoops to get that effort done. It's not just a simple snapping of your fingers. It's filing an injunction or filing, it's getting a lawyer in court involved. It takes time.
Yeah, we had to foreclose.
Yeah, sometimes it's clean and easy as just to foreclose,
Yeah.
even if you don't necessarily have to. Yes.
Can you do a rent to own and not have an option?
That would, if you're the seller, I would not do that.
Why not?
Because you're giving away flexibility that you would not otherwise have to give. So let's play that out. If I want to rent that house from you and I want to buy it, what do you gain by going ahead and locking in a price with me if I don't give anything for it? If the property appreciates, then I go snag it up and make that difference. I should have had to pay for that benefit. Does that make sense?
Yes.
So if you're not going to give me any extra money, why am I going to limit my options? The difference would be 2 years from now, you're still renting and you go, you know, I really like this place. I'd really like to talk about buying it. Well, that's great. Let's talk about buying it. It's worth a whole lot more now than it was when you first started renting it,
Right.
rather than locked in at the beginning. Now, if they give you money, okay, you locked in. That was the decision you made. You gave me $7,000, $8,000, $9,000. Hey, time value, money, and consideration. It made sense to do so. But I would never do that. There's nothing wrong with doing that, but that's not the preferred method. That's like just paying a little extra closing costs for them even though they didn't ask for it. Anyone else?
Good.
Good.
All right. Thank you, Todd.